My name is Muhammad Ali Nasir, and I would like to tell you a bit about my paper entitled Biopolitics, Thanatopolitics and the Right to Life. This essay forms a part of the larger research work that I have been doing on human rights, law and theory. I am interested in understanding how particular human rights address specific human aspects, such as, for example, the way the right to freedom of expression addresses the capacity of expression. This is important because, from a legal perspective, talk of human rights does not mean unless one specifies which right or rights one is talking about. This essay focuses on the right to life. What guided this inquiry was the idea that how life is understood, approached, and governed. Interestingly, the right to life protects life by stating exceptions. Thus, the right to life at the same time states circumstances when lives can be lawfully taken away. Thus, not everyone is given a right to live. In this light, this essay asks three questions. First, how and in what manner is it ensured that protection and deprivation of lives remain lawful? Second, how does the right to life apply equally on lives which are different? Third, how to understand the task of optimization of lives, that is, to understand the legal claims aiming at making lives more livable. By presenting the right to life as a biopolitical governmentality, in this essay and in my ongoing research, I identify 4 points, broadly speaking. First is the banal point that in order to be socially effective, human rights are a process. Importantly, what this means is that the shape of human rights and consequently of humanness depends on the rationalities through which they are articulated. Second, human rights protect right holders by defining the practices of government as human rights friendly. They therefore formulate legitimate ways of governing subjects in a free society. Third, human rights are to be guaranteed by the rule of law. In this sense, what is supposed to exist outside legal determination is to be simultaneously guaranteed by it. This also means that the subject of human rights has a duty to comply with the legal rules. Then, a lack of such a compliance can be legally punished by human rights. Fourth, human rights require not only an apt legal and political framework, but also an apt constitution of legal subjects in order to exist as a phenomenon. Similarly, when this aptness is not in place, even then human rights are legally able to tailor governmental practices so that there exists nothing outside the legal competence of human rights. This task is done by appreciating the variability of different circumstances and altering human rights accordingly. Enjoy reading the article, and I would look forward to your critical feedback on it. Thank you.